The objective today is to explain the significance of copyright. So intellectual property rights is an umbrella term that will cover copyright, trademarks, and patents. We'll briefly talk about each of those today, and then we'll settle our focus in on what it means to have a copyright and why that's important to protect it. What we've not started yet in class is using HTML styles. In progress, we're still practicing several types of elements and attributes in our HTML, and completed is your knowledge of what a tag is and how to use angle brackets to create tags. So what is intellectual property? This protects products of the mind. So you have patent law, which limited monopoly for new innovative products, processes, and designs. So there's this fine line between inventing something amazing and then only you are able to sell it. So there's going to be some allowance for that, and the details of the law, you can look at those, of course, and you can look at case-by-case basis, but there's basically a lot that goes into patent law. Next up, we have trademark law. This protects words, symbols, etc. that identify the source of goods and services against confusingly similar uses. Last week, we talked about the internet in China. Now, China's trademark laws are going to be significantly different than America's, and I guess by different I mean non-existent. So think, write, share. What is the difference between patents and trademarks? So justification for these laws, you have the natural law view. Persons have the right to reap the fruits of their creations. You have a utilitarian view. Copyright protection provides incentives for people to produce works of authorship. Think, write, share. Do you agree with both of these statements? Why or why not? U.S. Constitution, Article 1, Section 8, Clause 8, the Patent and Copyright Clause, empowers Congress to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Think, write, share. Do you think if the government did not protect people's right to make money from their creations, would they stop creating? I think that question is one of the most essential questions in the argument for intellectual property. The public grants an author a limited monopoly, giving up a public good. So under the Constitution, Congress can protect writings of authors, constructed to mean any physical rendering of the fruits of intellectual activity. Work must be recorded or written in some matter. Mere performance does not qualify. So there's some stipulations on your creations. Quick think, write, share again. Do you agree or not? Make sure to cut that out. Recently, a jury rewarded the estate of Marvin Gaye $7.4 million in the Blurred Lines case, sparking a firestorm of publicity. With this attention came a lot of dire predictions about how the case would be the end of creativity in music and in the music industry, possibly killing off entire genres of music. So I'm going to ask you an optional think, write, share right here. Do you ever listen to music illegally? Well, however you answered that optional think, write, share, just relax. In the article I found about this case, they said that most copyright cases aren't anywhere near that entertaining, and a lot of them have a great deal of potential to have a practical impact on copyright in the United States, including very noticeable impacts on end users. But as of now, we really haven't seen too much of that. In 2010, Oracle filed a lawsuit against Google claiming that the search giant violated their copyrights and patents in the creation of the Android mobile operating system. On the copyright of things, the issue centered around the Java programming language's application programming interface, also known as an API. Basically, an API is a set of instructions that tell an application how to interact with something else on the computer. So APIs are a big thing in programming. Quick think, write, share. What did I just say an API is? Google, wanting to make Android accessible to Java developers, copied that Java API through, though nothing else from the language was copied. Okay, so Oracle sued, claiming in part copyright infringement in the API. However, the lower court, ruled that APIs could not be protected by copyright, siding with Google. And the judge on this case was an interesting one to me. Apparently, he had spent a lot of time learning to program just so he can make a better ruling on this case. Oracle then appealed that ruling, which was overturned. Google has now put the case before the Supreme Court. And as of now, I have not heard anything new about this case. A great video here on YouTube, The Copyright Dilemma. And we're to the DOL. So create a one-page website using a P tag. Write a paragraph that justifies or argues against copyright. And then post your link on Canvas.